Hello everyone, welcome to another episode of our channel, Law Point. This is Shamal. Generally, a divorce can take place only if the court of law has passed an order to that effect. But when it comes to Muslims, a divorce can take place even without the intervention of court of law. We have our Supreme Court of India's advocate on record, Mrs. Praseena Elizabeth Joseph, to explain divorce laws among Muslims. So let's watch.
The Muslim concept of divorce is that if it is impossible for the spouses to live together, they must separate peacefully. The policy of Islam has been that, as far as possible, divorce cases shall not go to courts. Divorce signifies dissolution of marriage tie, and it can be initiated either by the husband or by the wife, or by mutual agreement between husband and wife, or by operation of law, that is through court. Please note that the word talaq means divorce initiated by husband only, and it is of three kinds: talaq-i-ihsan, talaq-i-hazal and talaq-i-bidat. Now let's see what is talaq-i-ihsan. Talaq-i-ihsan is a single pronouncement of talaq followed by a period of iddat. We have seen in our previous session that iddat is that time period for which a female divorcee has to abstain before marrying another person. In case of a divorcee, the iddat period is 3 lunar months. If the couple resumes cohabitation or intimacy during this period of iddat, then the pronouncement of talaq is being considered as revoked. If there is no resumption of cohabitation or intimacy during this period of iddat, then the pronouncement of talaq is presumed to be final and the marriage is dissolved after the expiry of the iddat period. Now let's see talaq-i-ihsan. Talaq-i-ihsan is 3 successive pronouncement of talaq by the husband. After the first pronouncement of talaq, 1 month iddat period need to be followed. If there is resumption of cohabitation or intimacy during this 1 month iddat period between the parties, then the pronouncement of talaq is considered as revoked. If there is no resumption of cohabitation or intimacy between the parties during this 1 month iddat period, then the second pronouncement of talaq is passed, followed by 1 more month of iddat period. Here also, if there is resumption of cohabitation or intimacy between the parties during this second iddat period, then also the pronouncement of talaq is considered as revoked. Otherwise, if the third talaq is pronounced after the expiry of the second iddat period, the talaq becomes irrevocable and the marriage stands dissolved. Thereafter, wife has to observe the required iddat period. It is significant to note herein that after 3 successive pronouncements of talaq, the couple cannot remarry each other unless the wife first marries someone else and her marriage with that person has been dissolved either by death or by divorce. Can the couple remarry each other? The third category is talaq-i-bidat. Here, divorce is effected by 1 definitive pronouncement of talaq by the husband, I talaq you irrevocably, or 3 simultaneous pronouncement of talaq, 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 uttered at the same time simultaneously. In talaq-i-bidat, the divorce is effective forthwith and it becomes irrevocable immediately, followed by a period of iddat. It is important to note herein that this kind of divorce is declared unconstitutional by the Honorable Supreme Court of India in the year 2017 in the case of Shayara Banu versus Union of India and others. Now let's see divorce initiated by wife. The first one is talaq-i-tafiz. Here the word talaq comes because here the power to divorce is delegated to wife by the husband. In this case, both parties to the marriage enter into a marriage agreement listing out the terms and conditions of marriage. If any of the terms and conditions of this marriage is not fulfilled by the husband, then the wife can seek divorce. A Muslim wife can also seek divorce on the ground that her husband accuses her of false charge of adultery. Third category of divorce is divorce by mutual consent. These are of two ways. One is khula and second is mubarak. Under khula, the offer of divorce is from the wife and it is accepted by the husband. Here the wife is purchasing her divorce from the husband by paying monetary consideration to the husband. It can be in the form of waiving off her meher, which is due from the husband, or any other rights. Second category is mubarak. It is also a form of mutual consent divorce only. Here both parties feel that they are not compatible together. Here both parties decide to dissolve the marriage mutually. In case of mutual divorce also, the divorced wife is required to observe either period. Fourth category of divorce is divorce obtained through court of law. We have seen that a Muslim husband can divorce on any ground or even without any reason. However, a Muslim wife had only very limited ground for divorce. So, to enable a Muslim woman to get her marriage dissolved by an order of the court, Dissolution of Muslim Marriages Act of 1939 was passed. The grounds on which a Muslim wife can seek divorce are as follows. If the husband is missing for a period of 4 years, then the wife can seek dissolution of marriage. If the husband is not financially maintaining his wife, either because he neglects or he doesn't have sufficient means to maintain her, then the wife can seek divorce on this ground. Thirdly, if the husband has been sentenced to imprisonment for a period of 7 years or upwards, the wife can seek divorce. Fourthly, if the husband has failed to perform his marital obligations for a period of 3 years without any reasonable cause, then it is another ground for divorce. Fifthly, if the husband was impotent at the time of marriage and continued to be so, then it is another ground for divorce. If the husband is of unsound mind for a period of 2 years or is suffering from leprosy or any disease of the sex organs, then it is another ground for divorce. If a Muslim wife have been given in marriage by her father or guardian before she attained the age of 15 years, then she can repudiate the marriage when she attained the age of 18 years, provided the marriage is not being consummated. Finally, if the husband treats his wife with cruelty, that is another ground for divorce. Cruelty includes habitually torturing the wife or assaulting the wife or disposing of her property without her consent, or if the husband has more than one wife, he is not treating this wife equitably in accordance with Holy Quran, etc. So, to sum up, today we have seen 4 ways in which a Muslim marriage can be dissolved. One is divorce initiated by husband, second is divorce initiated by wife, third is divorce by mutual consent, and fourth is divorce obtained through court. Thank you.
Thank you for watching. Stay tuned.